Hello, welcome to my channel. Today, we are going to study constitutional law for the uniform bar exam. We are going to study a commercial speech, a commandeering, and a dormant commerce clause question. Prior to the question, let's check the rule related to the commercial speech. Truthful commercial speech may only be regulated if the regulations satisfy intermediate scrutiny. 1. Serves substantial government purpose. 2. Directly advances that interest in. 3. Narrowly tailored to that interest. Now we are going to read the question. City enacted an ordinance banning, from its public sidewalks, all machines dispensing publications, consisting wholly of commercial advertisements. The ordinance was enacted because of a concern about the adverse aesthetic effects of litter from publications distributed on the public sidewalks and streets. However, city continued to allow machines dispensing other types of publications on the public sidewalks. As a result of the city ordinance, 20 of the 200 sidewalk machines that were dispensing publications in city were removed. Is this city ordinance constitutional? A. No, because there is not a reasonable fit between the legitimate interest of city in preserving the aesthetics of its sidewalks and streets and the means it chose to advance that interest. B. No, because it does not constitute the least restrictive means with which to protect the aesthetics of city sidewalks and streets. C. Yes, because city has a compelling interest in protecting the aesthetics of its sidewalks and streets, and such a ban is necessary to vindicate this interest. D. Yes, because regulations of commercial speech are subject only to the requirement that they be rationally related to a legitimate state goal, and that requirement is satisfied here. Before I release the answer with the reason, I am going to wait for you a little bit. Or you can pause the video if you need. Can you guess what the answer is? Alright, as you guess, the answer is A. No, because there is not a reasonable fit between the legitimate interest of city in preserving the aesthetics of its sidewalks and streets and the means it chose to advance that interest. This is because city is attempting to regulate truthful commercial speech by banning from public sidewalks all machines dispensing publications consisting wholly of commercial advertisements. The reason for this ordinance was a concern about the adverse aesthetic effects of litter from publications distributed on the public sidewalks and streets. The problem with the city's action is that the city continued to allow machines dispensing other types of publications on the public sidewalks. And these other machines present the same problem as machines dispensing commercial advertisements. Also, since only 20 of the 200 sidewalk machines were removed, these commercial advertisements were only 10% of the problem. This ordinance is not narrowly tailored to serve the government's interest in protecting the aesthetics of its public sidewalks, and as such, it would be held unconstitutional. Alright, you want another question? Then, please hit the thumbs up and subscribe right now. Before we jump into the next question, let's check the commandeering rule. Under the 10th Amendment, all powers not granted to the United States, nor prohibited to the states, are reserved to the states or the people. For this reason, Congress is prohibited from compelling state legislative or regulatory activity. Congress, however, can induce state action via strings on grants. But these conditions must be expressly stated, and the conditions must relate to the purpose of the program. Alright, this is the next question. Current national statistics show a dramatic increase in the number of elementary and secondary school students bringing controlled substances to school for personal use or distribution to others. In response, Congress enacted a statute requiring each state legislature to enact a state law that makes it a state crime for any person to possess, use, or distribute within 1,000 feet of any elementary or secondary school any controlled substance that has previously been transported in interstate commerce and that is not possessed, used, or distributed pursuant to a proper physician's prescription. This federal statute is a. constitutional, because Congress possesses broad authority under both the General Welfare Clause and the Commerce Clause to regulate any activities affecting education that also have, in inseverable aggregates, a substantial effect on interstate commerce. B. Constitutional, because it contains a jurisdictional provision that will ensure, on a case-by-case basis, that any particular controlled substance subject to the terms of this statute will, in fact, affect interstate commerce. C. Unconstitutional, because the possession, use, or distribution, in close proximity to a school, of a controlled substance that has previously been transported in interstate commerce does not have a sufficiently close nexus to such commerce to justify its regulation by Congress. D. Unconstitutional, because Congress has no authority to require a state legislature to enact any specified legislation. Before I release the answer with the reason, I am going to wait for you a little bit. Or you can pause the video if you need. Can you guess what the answer is? Alright, as you guess, the answer is D. Unconstitutional, because Congress has no authority to require a state legislature to enact any specified legislation. This is because Congress enacted a statute requiring each state legislature to enact a state law. That makes it a state crime for any person to possess, use or distribute within 1,000 feet of any elementary or secondary school has previously been transported in interstate commerce, and that is not possessed, used or distributed pursuant to a proper physician's prescription. This would be a direct violation of the 10th Amendment. Thus, this federal statute would be unconstitutional. One more question? Then, please hit the thumbs up and subscribe right now. Here we go. Recently, several large corporations, incorporated and headquartered in State X, have suddenly been acquired by out-of-state corporations that have moved all of their operations out of State X. Other corporations incorporated and headquartered in State X have successfully resisted such attempts at acquisition by out-of-state corporations, but they have suffered severe economic injury during those acquisition attempts. In an effort to preserve jobs in State X and to protect its domestic corporations against their sudden acquisition by out-of-state purchasers, the legislature of State X enacts a statute governing acquisitions of shares in all corporations incorporated in State X. This statute requires that any acquisition of more than 20% of the voting shares of a corporation incorporated in State X that occurs over a period of less than 1 year must be approved by the holders of record of a majority of the shares of the corporation as of the day before the commencement of the acquisition of those shares. The statute expressly applies to acquisitions of State X corporations by both in-state and out-of-state entities. Assume that no federal statute applies. Is this statute of State X constitutional? A. Yes, because corporations exist only by virtue of state law and, thus, the negative implications of the Commerce Clause do not apply to state regulations governing their creation and acquisition. B. Yes, because the statute imposes the same burden on both in-state and out-of-state entities wishing to acquire a State X corporation. It regulates only the acquisition of State X corporations, and it does not create an impermissible risk of inconsistent regulation on this subject by different states. C. No, because the effect of the statute will necessarily be to hinder the acquisition of State X corporations by other corporations, many of whose shareholders are not residents of State X and, thus, it will adversely affect the interstate sale of securities. D. No, because one of the purposes of the statute is to prevent out-of-state entities from acquiring corporations incorporated and headquartered in State X. This time if you know the answer for this question, type your answer with the reason in the comment box. I will leave the answer on my Instagram study 4 bars. Follow me on Instagram and check the correct answer of this question. I hope today's video was helpful to your bar study. If you want to study more for the UBE, don't forget to subscribe. Happy study!